Hello, everyone. This is David Epstein. I'm the chairman of the Legal Issues Committee for the California MBA. Our vice chairman is Jered, who is not with us today. And the next person is Ian Rambaran. And I don't think Ian is with us because he has a deposition that he was stuck in the middle of. We have a very interesting program today with three major topics, two really long major topics, and one additional topic on HBOR, a second topic on the Mulvaney strategy statement, and we're going to begin, and then there's the third topic on the Me Too movement. And so I think these are all very timely. So with that, we always begin with a legislative report that Dustin does. And Dustin, if you could do the presentation on that, that would be great.
Great, thanks, David. Appreciate it. So I'll try to be quick here. As David mentioned, we've got a lot of good speakers today. So I'll go through a couple of the bills that are hot topics this year. And just a brief note before I begin, our annual legislative day is coming up this Monday, March 12th, here in Sacramento. And if you would like to join us, we'd love to have you. There's still opportunity to join. And as we do at those meetings, you'll get to meet our lobbyists, hear directly from them about the bills themselves, the status, support, oppose, why, all that kind of good stuff. And then we go over to the Capitol building here in Sacramento and meet with key members of the Senate and Assembly Banking and Finance Committees. So it's a great opportunity to make your voice heard on these bills that I'm mentioning here. So the first one is AB 2358 by Assemblymember Calderon, and it deals with remote online notarization. This is a topic that is kind of sweeping state legislatures right now. It's got the support of the the National Association of Secretaries of State, and I think it's already law in 5 states now, I believe. And this sort of takes the next step in mortgage finance. And as many of you know, the front end of the transaction is very much digitized at this point and online and consumer friendly. And the back end the closing of the loan is kind of sort of where that process stops. And so this takes the next step there and would institute a remote online notarization regime here in California, and the California MBA is a proud supporter of that. So that's AB 2368. The next one is SB 818 by Assemblymember Beal. This deals with the Homeowner Bill of Rights, and as many of you know, the major provisions of the Homeowner Bill of Rights sunset last year, and at the end of 2017. And so this bill would pick up on that and reinstitute many of the protections and provisions of the Homeowner Bill of Rights. However, there are a few problems with it from our perspective. It doesn't have a new sunset date for it, which is a major problem. Usually bills like this typically have a sunset date. This one does not, and so it would essentially in perpetuity maintain these same standards and provisions. And as many of you know, the cost for servicing a loan and the timeline on foreclosures has gone up dramatically in the last decade. And we feel that when you take into account the issue of a lack of a sunset date, in addition of a few more provisions here that were not included in the original Homeowner Bill of Rights, you've got a problem there. You also have the issue of the CFPB already instituting national servicing standards that sort of in many ways makes these provisions a bit moot, and many of the problems that we saw in servicing have also been taken care of on the front end through the ability to repay reform and qualified mortgage requirements. So that's SB 818. That one is in the Senate Banking and Finance Committee at the moment, where it's being heard, I believe, in the next week. So the final one I wanted to mention was SB 1087 by Senator Roth. And this deals with, this is cleanup language for the PACE bills that were passed last year that we supported. And so this is sort of just a technical fix on some issues that PACE bills that we supported and were passed last year were sort of done a bit at the last minute of the session. And so this is sort of a typical cleanup that needs to be done for bills that are passed in such a manner. So nothing too major to deal with this. The only thing I'd mention in here is that it does add some new some new protections for homeowners. It requires that PACE administrators underwrite homeowners even earlier than was required in last year's bill to ensure that homeowners know whether or not they're going to qualify for PACE financing before they obligate themselves on a home improvement contract with the expectation that they're going to get that PACE financing. So that's all the bills I have. I would, again, encourage anyone who's interested to go to our website and check out information about our legislative day this coming Monday. There's still opportunity to join us here in Sacramento. So with that, David, I'll turn it back over to you.
Thank you, Dustin. The next issue is an issue that came up only in the last several weeks. Many people are in the position of defending HBOR claims, Homeowners Bill of Rights claims, and there was an issue that came up with a defense that appeared new, and Jane Kutepova is going to speak with us about that. Jane has a background in mortgage, real estate, and financial services industry, and she's with the firm Hall Huguenin. Jane, do you want to go ahead?
Absolutely. Thank you very much. So I'm going to be talking to you guys about the repeal rule. So the first thing is, sorry, just making sure the slide works. So the first thing is that we want to talk about HBOR. I'm sure all of you know what HBOR is. HBOR really deals with California's response to the foreclosure crisis, and that was roughly, it started being effective in January 1st, 2013, and therefore it's not retroactive. There you go. So the goal was really to encourage foreclosure mitigation, as you all know. And regarding the self-repealing provision specifically, in 2013, HBOR statutes were not permanent. They were actually self-repealing, and it had a date that now it was supposed to stop being effective as of January 1st, 2018. And the most important part of this provision is the fact that it deleted or extended that date. Now, if legislature wanted to, it could have deleted or extended that date, but that's not what they did. Now, HBOR currently is not gone. There's a 2013 version that was replaced with a new version. It was effective January 1st, 2018. It adds some good stuff, some bad stuff, but obviously feel free to reach out to us if you want to discuss more on what it adds. But since 2013 HBR is gone, what does that mean for actual actions that were filed after 2018? The prevailing theory is that 2013 HBR can still be enforced from the dates of 2013 to 2017 for any violation, even if the suit was not filed by January 1st, 2018. But there's been a new theory, and that theory, making sure, now that theory states that realistically 2013 HBR is gone because of the repeal rule. The repeal rule states that when a pending action rests solely on a statutory basis and when no rights have vested under the statute, a repeal of such a statute without a savings clause will terminate all pending actions. Now, the second portion of the repeal rule, the repeal of 2013 HBR arguably takes immediate effect in all cases and as to all 2013 through 2017 actions if they're not already finally adjudicated. It's also a general rule that a cause of action or a remedy depending on the statute that falls within the repeal of the statute, even after the action is pending, in the absence of a savings clause in the repealing statute. Now, the issue that we're having here is basically that since that 2013 statute was repealed, the new statute, is it actually going to be effective for cases that are brought between the after January 1st, 2018, based on the old HBOR? It's an untested argument, but a lot of people, there is an argument out there that states that no, you cannot rely on the old HBOR. Now, that can be a great thing or that can be a terrible thing, because technically there's a lot of great law that judges have made for us. And those, are they going to interpret everything the same way? They might not. It is also an argument potentially worth making in the right case. So for example, if Berman, a case that deals with materiality, is something that you don't necessarily want as part of the new HBOR, that's a great argument to make as well. And that's it. Thank you, guys. I'll turn it over to you, Dave.
Thank you very much, Jane. Very much appreciated that. All right, the next subject is a subject that's been very much in the news ever since the president appointed Richard Mulvaney as head of the CFPB. And we're very fortunate today that we've secured the participation, a presentation by Richard Andreano, who is a practice leader of Ballard Spahr's mortgage banking group. He's worked for over 30 years in the area of financial services, and I asked for a short biography to introduce him to you, and all I can tell you is I could spend the whole 15 minutes just going through his biography. We're so fortunate to have Richard with us. Just as with Photoshop, they say that there's no one person who knows all of Photoshop. There's no one person who knows all of CFPB, but Richard comes as close as anyone. So Richard is here to talk about the Mulvaney strategy, and I'll let you do that now.
Thank you very much, David, and good day to everyone. What I first wanted to address is the kind of elephant still sitting in the room, which is the challenge to the ability of Acting Director Mulvaney to, in fact, serve as Acting Director. And what happened is back after Thanksgiving, what happened was former Director Cordray elevated Leandra English to Deputy Director and then resigned. And then President Trump, using the Federal Vacancies Reform Act, appointed Mick Mulvaney as Acting Director. Now, Leandra English challenged that, first in the District Court here in the District of Columbia. Those challenges were denied, and it's now on appeal up to the Court of Appeals here. Now, interestingly, there are some timing issues here. Under the Vacancy Act, generally there's a 210-day limit on the length of time an acting director can serve. However, if the nomination for the permanent director occurs in that time, the acting director then can continue. That 210-day limit runs out around June 22nd, so it's really not that far off. The real issue here is Leandra English is claiming that DoddFrank is the sole and exclusive provision that controls here, and it has a provision that the deputy director serves in place of the director in the absence or unavailability of the director. The government's position is that, well, yes, but there's also a Federal Vacancies Reform Act, and Dodd-Frank doesn't supplant that. We think there's actually even an initial issue that probably the government should argue is that Dodd-Frank probably doesn't even apply, because Dodd-Frank refers to the absence or unavailability of the director. Our position is he's not absent or unavailable. He's gone. The position is vacant, and federal law deals with vacancies much different. There are also some constitutional issues here that have been argued by some of the amici supporting the government. But the real issue here is there some question as to the continuing ability to Mick Mulvaney serve as acting director? Actually, there is. Now, oral arguments aren't until the 12th, which means we might not have a decision before a permanent director has been actually nominated. And remember, President Obama first put Director Cordray in place with a recess appointment, and President Trump might do that. So I want to leave that as a possibility as well, that potentially could happen. But now let's move on to actions by the director. What he did is first come in and put a 30-day freeze on pretty much everything. Technically, that's expired, although we're seeing that in many respects there is a bit of a freeze in different areas, and also a freeze on collection of personally identifiable information until the Bureau fixed its data security issues. We've seen that have an effect on enforcement supervisory matters that seem to have slowed down because you can't collect information that has personally identifiable information, and a lot of information requested in enforcement and supervisory actions would. But what we also think is occurring, that enforcement actions or investigations that were in their early stage are being reviewed. From what we understand, if enforcement action had reached a late stage, they're probably not going to be renegotiated. But we think early stage issues, investigations, and enforcement actions are being looked at. And we've seen that personally because we've seen a lot of radio silence from the Bureau in this area on matters that we're working on. Now, here is a list of various requests for information that have been issued, and Acting Director Mulvaney had indicated that the Bureau was really going to relook at everything it was doing and seek public input. That's what these RFIs are, in fact, intended to do. And what I've listed there is the various ones when they appear in the Federal Register, so you can go there and read them, and the various comment deadlines. The latest just came out yesterday, and it should be published in tomorrow's Federal Register on rulemaking process. That's on the process in general. The Bureau said that next week it will issue an RFI on actual rules that have been adopted. So that will be our chance to actually comment on specific rules. Just a few things I'll quickly point out here. The civil investigative demand, that's has been considered very onerous. So a lot of the industry is going to respond on that, that it's just so burdensome that companies are effectively bludgeoned into submitting to consent orders. Administrative adjudications also viewed as an issue. PHH case is probably the greatest example of that. They first had to go for an administrative law judge, then both sides appealed, and the person who heard the appeal was Director Cordray, sort of like when an NFL player gets disciplined and they appeal, the appeal was heard by Roger Goodell. That didn't go particularly well, and we know the Director Cordray took fairly ridiculous positions on RESPA in that, and only after that could PHH get to a real court, which was very critical of a lot of things the director, in fact, had done. So that's important that that process be looked at. And enforcement proceedings in general are going to be looked at. One is the length of investigations, and also with civil money penalties. The thought is a lot of agencies have a matrix, so people have an idea of what the penalty will be, and there's some guidance as to what the penalty will be. So the issue is, should the Bureau, in fact, adopt such a matrix? In general supervision, they're looking at that. That has not really been now more recently. People have found that process to be working fairly well. But one thing to focus on is the document request that you get initially. It's very substantial and burdensome. So they want to look at that, and they want to look at the effectiveness of the exam manual. Consumer complaints and what's published on them, that's something that gets a lot of attention. Particularly the view is you put some of these complaints, which are unverified, but you put it on a government website, it has a tinge of authenticity to it. And so it looks like they're going to look somewhat on that. Do they put also companies' positions, more of the company position on websites, or do they limit access to the database, which is really, I think, what the industry would like to see, because a lot of this is unverified information that could be quite damaging, and yet it's often not quite accurate of what's actually occurred. Now let's look at some of the things that got a lot of attention. No more pushing the envelope statement. Former Director Cordray, Senator Warren really didn't like that, but we all know that the Bureau, in fact, has stretched and overreached in many cases, and that what Director Mulvaney has indicated, that they're going to take a more balanced approach and consider the size of the companies who are supervised in addition to consumers, and that's something that's needed. Also, something a little blown out of proportion. He said he was requesting $0 for fiscal year 2018, and people said, oh, he's going to bleed the CFPB dry and shut it down. Well, they still had $177 million in the bank with only $145 million in estimated expenses for the quarter. Plus, all they have to do is send a letter to the Fed, and the next day they wire millions of dollars. So it was really done more symbolically, and people who were saying it's trying to shut the Bureau down. No, what he just thought is having a reserve, which is what Director Cordray wanted to do, wasn't fiscally responsible, and that they had enough money, and he was not going to ask for more if they had enough money. The strategic plan, it's the second one. The first one issued was for 2013 to 2017. This covers fiscal years 2018 to 2022. It has some statements that you would have never found from Director Cordray, saying they will not push the envelope because that ignores the will of the American people and could risk trampling upon the liberties of our citizens. Very different approach. Objectives are to equally protect the rights of all. That includes the supervised as well as consumers, and to act with humility and moderation, and that's something we did not see from the Bureau in the past. The other thing that got a lot of attention is he took Director Mulvaney, the Office of Fair Lending, moved it pretty much under the director, and there they will focus on advocacy, coordination, and education. The enforcement supervision part of it stayed within the existing Office of Supervision, Enforcement, and Fair Lending. Issue is going to be, how does this play out in reality? And that we're going to have to actually wait and see what really happens with that reorganization. But that was criticized heavily by some, but I said, let's really see what happens before we get critical. Now, what about the mortgage industry itself? one thing the Bureau has said it would do is look at the HMDA rule. It actually approached the industry at the end of last year to see if it could make any changes before the rule became effective on January 1. And really, there just wasn't enough time, and there were too many divergent opinions at that point as what to do last minute. But now it said it's going to look at it. One thing it's going to look at is the institution and transactional coverage. So expect there to be changes. Right now, for closed-end loans, the trigger is very low. It's 25 loans in each of the past 2 years. Will that return to 100 loans or perhaps another number? I expect so. For HELOCs, we have a temporary trigger of 500 in each of the past 2 years. Now, the Bureau already was reconsidering the original number of 100. I suspect the 500 or higher number will be what, in fact, gets put into place. But also, they're going to look at the discretionary data points. By the Bureau's count, the rule took the data points, the main categories, not the subcategories, from 23 to 48. And that there were 25 new categories, 11 were in DoddFrank, 14 were added by the Bureau. So it's that 14 that are going to be looked at. Now, among those 14 new items that the Bureau added are some important items: the interest rate, discount points, origination charges, lender credits, and information on the underwriting, the automated underwriting system, and the result put out by the system. So those, if those were removed or scaled back in somewhat, very helpful for the industry. Now, pursuant to Dodd-Frank, the Bureau has to publish a report no later than 5 years after the effective date of a major rule, an assessment of that rule. Well, believe it or not, the ability to pay rule and servicing rules became effective January 10, 2014, so we're less than a year to the 5-year anniversary of that. Believe it or not, how time has flown. And the Bureau is already engaged in reassessments of those rules. In that, through industry advocacy, the Trump administration had already indicated with the ability to repay rule that the Bureau should engage in a review of the rule to align the QM requirements with the Fannie and Freddie eligibility requirements and eliminate the so-called QM patch for Freddie and Fannie loans. The thought is, take the underwriting standards used by Fannie and Freddie, and not as Fannie and Freddie standards, but as underwriting standards, make them the core of the QM rule, which, if followed, would make a loan QM whether or not it's eligible for sale to Fannie or Freddie. That is the basic thrust there, and that is something the industry believes would be very helpful, because that patch, the QM patch, goes away in January 10, 2021, not that long away, so we need a fix for that. The servicing rules also, one thing the Bureau never did is really look at the cost benefit. What was the cost of a requirement in relation to the benefit? Mulvaney said they will look at cost benefit, and that's very important with the servicing rules and all the other ones, because one point that I've continually made, that consumer protection does not have a consumer who has the credit profile to obtain a mortgage loan, but can't because the costs of the loan are now so expensive because of the regulatory obligations. That doesn't protect that consumer. So really giving a thought to cost benefits is important. And our favorite still, went too far, but the TriG Rule, before I think I clicked twice by mistake.
Oops, we got into the next subject.
Yeah, got into
That's
next,
right.
so I'm still on this. The TriG Rule, just a few comments on that. I think I hit the mouse twice there. It is a mess, and we know the TriG Rule is a mess. That has been communicated to the Trump administration and to Mulvaney, that it needs work. What we really found is when we went to the Bureau in the past, they really said they didn't have much resources to work on the TriG Rule or other rules. And we were sitting there saying, what do you mean? You get millions of dollars every quarter from the Fed. What do you mean you don't have resources? And what it simply was is that the Bureau had, by statute, written a lot of mortgage rules and didn't want to devote the staff time to really fixing those rules and addressing problems that the industry brought to them, unless there were significant consumer harm involved. If it was to fix things or make it more efficient, they really didn't care about that at all. That obviously will change in focus. So TriG Rule, we all know the TriG Rule needs work, and we think that new Bureau and the new leadership will look at the rule. What we have to be careful, though, is remember in not that long ago, we implemented a major revision to the GFE requirements. Then we threw those out and implemented the TriG Rule. We have amendments to the TriG Rule that were minor, but it still required various changes. But the rule needs a lot of work. But what we don't want is changes that are so dramatic that we're implementing almost yet a third rule. And plus, we don't want changes that'll be reversed in a few years if there's another director. So what we need is sensible changes that fix the problem, but don't swing the pendulum so far that we have to do a lot of reprogramming and retraining and new policies and procedures that another administration will just reverse. So we need changes, but it has to be done in a thoughtful manner. With that, I turn the presentation back to David to introduce the presenters for the Me Too presentation.
Thank you very much, Richard. It's really helpful to have those kinds of specifics because we get these broad statements that we all read in the news and we to try and make sense about what the strategy is. Our next topic is also very similar in the sense that if anything has been in the news and that we're all aware of, it's the Me Too movement. And so the question arose, how does the Me Too movement impact the mortgage industry? I'm not sure how we stop that noise, but in any event, we're very fortunate. We have two speakers on that. We have John Cohn, who is of counsel to Hall Huguenin, and we have Abe Salen, who is a senior litigation attorney with the Wolf firm. They have each spent many years, John 35 years, Abe with 20 years experience in dealing with areas of sexual harassment and discrimination. And so I'll let the two of you proceed.
All right. Yes, good afternoon, everyone. Abe Salen, Wolf Firm. Today we're talking about the Me Too movement or the Time's Up movement or whatever you want to call it. The focus that John and I have today is to really talk about the movement from the standpoint of what is deemed harassment and how an organization or an employer can respond appropriately to ensure that they are not sued for a lot of money. That's the key. I'd like to start off with sort of two whoops, I don't know how to go backwards, but two comments. So you have an employee, a manager who walks into the office every day and says to the receptionist, "How you doing?" And my thought process on that was, is that sexual harassment? And the key is that it depends on what the receiver of that comment believes. It doesn't go to what a supervisor might think that comment is or what the person who said it believes it means. He might think it means nothing. But just like we have eggshell plaintiffs and torts, we have eggshell employees, and we take them for who they are. So if they believe that how you doing is offensive, then that behavior has to be discussed from a supervisor standpoint. So we look at harassment generally, and I put on here pervasive and repeated, because you can have a, "Hey, you look sharp today," as a statement, but if it's never said again, it might not be deemed harassment, even though it's offensive to the person that it is said to. An employer, as we all know, is vicariously liable for the conduct of its employees in terms of harassment issues. What that means is that if an employee says something to another employee, the victim can sue the employee for harassment, but more importantly, they can sue the employer, who likely has bigger pockets than the employee who said who did the offensive conduct. thus, for years, and this really goes to the Me Too movement, for years we've seen conduct that is difficult to discern. It's not just someone saying great tits or something, pardon my language, or grabbing somebody. Those are obvious. But it's the conduct that managers sort of brush to the side or wave off or go talk to the person and the perpetrator says, hey, I didn't mean anything by that. Come on, guys, you know me. I'm innocent. I'm married. I have kids. I don't mean anything. And the supervisor says, yeah, he didn't really mean anything by it, and nothing's ever done, and it ends up being ignored until it becomes a much larger problem. Weeks versus Baker and McKenzie, there's a site there. It's a California case. It's one of my favorite cases, quite frankly, because everything that you shouldn't do as an employer is in this case. Weeks was a secretary who sued Baker and McKenzie, a gigantic law firm, national law firm. And the reason she sued was because Baker and McKenzie had a partner, Mr. Greenstein, no relation as far as I know to Mr. Harvey Weinstein, but who had similar thought processes. And basically what Mr. Greenstein did was he leered at people, he touched them the wrong way, and it happened over a several year time period. And whenever someone complained, they might have been moved to a different department, or they scolded the partner but didn't do anything. They finally moved him out west to their Palo Alto office, where he continued in his offensive behavior until it grew into a case. And basically, what the Weeks case shows us is that we have to have, as an employer, we have to have a code of conduct. The code of conduct needs to identify what offensive behavior is, and John's going to talk to that. And in particular, it needs to talk about, the code of conduct has to provide a course of action for the management to deal with, not just to deal with the accused and how to obtain the information and to investigate it, but how they deal with the person, the perpetrator, and it needs to have a time frame, and the investigation has to be formalized, and it needs to be swift and zero tolerance. So, code of conduct, I just mentioned that. Fannie Mae, I looked on theirs. Sexual harassment is their first principle. And basically they're talking about any offensive conduct or behavior that the victim feels is offensive, and how to deal with it. And what they do is they put this out to all their employees, and they provide guidelines. If you believe that someone is conducting themselves offensively, this is how you report it. If you believe that you've been victimized, this is how you report it. And then as a management system, this is how you go about investigating it. And it has to be a change in the lifestyle of the workplace. I think that's what the Me Too movement's really talking about when they say time's up. It's, yeah, this conduct has been happening for a long time. I mean, if we look at the Weeks case, the case was from 1998, and it dealt with conduct from the 1980s into the early 1990s. So the conduct's always been there. The issue that we're dealing with now is that companies have to come up with a plan of action for dealing with it, and dealing with it so that it does not rise to the level of a lawsuit. Take a look again at Weeks. Baker and McKenzie was sued, and they lost $3.5 million worth in a punitive damages award against them. They were held liable because they kept brushing it aside. They kept brushing it aside. And that's the conduct that needs to end. The last slide I have just reminds everybody that conduct doesn't have to come from within. It can come from anybody. And if it's offensive to somebody in your organization, the organization has to take steps to terminate it and deal with it. Anyway, that's my slide process. Now John's going to talk about harassment from a more specific line of dealing with it. John?
Thanks, Abe, and thank you all for having me. I always get a little worried when someone introduces me as being an expert in sexual harassment. I think it's more appropriate that maybe I would rather be an expert in prevention of sexual harassment. But we've essentially gone through a tectonic shift now. And when Time Magazine identifies the person of the year as those that are reporting sexual harassment, you know you've got a change in the cultural nature and really the impact that sexual harassment is going to have in the workplace. You know, just a little bit of the background. I know that we have some folks here that deal with issues that are a little more national in scope and others that are more focused on California. So for those that are dealing with non-California focus, Title VII is the fundamental basis for sexual harassment prevention. Essentially, it starts out as discrimination, and it says there can be no discrimination based on the following elements: race, color, religion, sex, and natural origin. Later on in '86, U.S. Supreme Court ruled that harassment based on sex is also considered discrimination. So that expanded the level of protection that was available to employees. And then we started with this focus on the U.S. Supreme Court case in Meritor, which defined what is harassment. And harassment was identified as intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. The most critical component of that was this term, severe or pervasive. So severe was identified as a single act that could be serious enough to cause harassment, and pervasive was there could be multiple smaller acts of harassment that could alter the conditions of employment and create this hostile work environment. Fair Employment and Housing Act is the California corollary that has expanded Title VII and applies to businesses that are of a size of 5+ employees. However, harassment safeguards apply to any employer that has 1 or more employees. So all employers essentially are subject to the FEHA protections. FEHA expanded substantially the nature of the categories. I used to be able to memorize these, but now it's become so expansive and changes so frequently that you know, I just list them, and in some cases, many of these categories are actually rather difficult to understand and are still being interpreted. But it gets broader than that, because it's not just that you're discriminating against people in those protected categories, it's also the perception that this person may be involved with or have those categories, whether you're right or wrong, or are associated with those who are perceived to have those characteristics. So extremely broad, and the Department of Fair Employment and Housing, who enforces that, interpret that as being extremely broad. It doesn't just apply to what we consider to be garden variety employees. It applies to interns, volunteers, and independent contractors, and it also protects employees from third-party independent volunteers, independent contractors, and volunteers and interns. So you got to watch out for the kinds of things that are being said by your UPS or FedEx delivery personnel. Anytime something like that is occurring and it impacts your employees, you are subject to claims and restrictions based on harassment. So what is harassment? Essentially, it's identified as unwelcome advances of a sexual nature. 2 forms. The first is quid pro quo. You know, in my nearly 30 years of practice, I have not seen that many quid pro quo cases. That's the one where the terms of employment are dictated based on an exchange of sexual favors. That's a pretty crude identifier of what sexual harassment looks like. That's kind of rare, and I think most perpetrators of this are not are a little more sophisticated. This is the one that tends to be the cause du jour for harassment issues. It's hostile work environment, and that is a conduct in the workplace that is intimidating, hostile, or aggressive. I've spoken with folks in the EEOC and the Department of Fair Employment and Housing who identify this as saying, hey, look, it's just like being in a place that feels too hot all the time. It's just this generic sense of what is happening in the workplace, and it just doesn't feel right. A
2 minutes.
pretty ambiguous concept, no doubt, but that's sort of the explanation that they like to present. So what's happening in the employment litigation aspects with Me Too? Well, you know, we've all been kind of watching. Most of us would say that right about the end of 17, towards the beginning of 18 is when issues involving Me Too started to present themselves in the culture. So most of us wanted to see how that would translate in lawsuits based on discrimination and harassment. Well, we were following a case that was filed against UCLA. The verdict just came out less than a month ago. Pinder Brown versus UC Regents. Those of us in legal follow the Daily Journal, and it seemed like there was reports on this particular case almost daily as it was progressing through the LA court system. Essentially, it was a discrimination retaliation claim, and it was by a UCLA, it was against UCLA by a medical school professor who was tenured, had a great deal of background. She eventually she quit, claiming that that her conditions of employment were so severe that she felt obligated, and no reasonable person would have believed that she should have endured that level of harassment and discrimination. It turned out underlying facts said that she'd had a job lined up more than in a year advance of her termination. Some, I thought, compelling facts for the defense. She argued that because it was a supervisor who was engaging in harassment, that it was strict liability, which is the law in California and in most jurisdictions. So we waited anxiously to find out what the result was going to be. $13 million. And so that was the first salvo of what is happening in regards to, I think, the general public sense for this pent-up issue involving Me Too movement, sexual harassment, and discrimination, and frankly, it does not bode well. What's happening politically? Well, you know, confidential settlement, that sort of was the stock and trade for most employers and even many employees in resolving these disputes. So what would happen is when these things were being resolved, employers, it was in their best interest to make sure that there were non-disclosures of the terms of the settlement, the basis for the settlement, et cetera. It's standard boilerplate in most every settlement that involves either harassment or discrimination or most workplace issues. So the legislature, there's several bills before the California legislature indicating that they want to avoid these non-disclosures so that the world can hear about confidential settlements. A lot of this confidentiality was one of the major features that would guide employers to settle. So the unintended consequence of doing this is essentially employers say, look, we cannot, we're always going to bear either the political or the public impact of this because it can't be kept confidential, so why not try the case? And so whatever value was inherent in a confidential settlement that would benefit even an employee in determining the value of her case, that no longer is in existence or may no longer be in existence if our legislature has its way. Arbitration, there is a movement to avoid most employers, certainly the ones that I represent, I urge them to have arbitration agreements with their employees. A lot of these arbitration clauses impact things like discrimination cases, sexual harassment cases, and in many cases, class actions can be taken out of the court system and brought into arbitration. However, the political movement is suggesting that we should have a carve-out for issues involving sexual harassment and discrimination. And if arbitration is gone, that's going to mean that the expediency, at least for employers and even employees in many cases, is going to be gone. I think a lot of these political solutions are probably over time going to come back and probably haunt most of those who were purportedly to be benefited by them. So how do we defend these things? First of all, every employer needs a robust harassment prevention policy. Why? Because the law requires it. In California, there's a statute, it's in the government code, and it says employers must take all reasonable steps necessary to prevent discrimination and harassment from occurring. One of those reasonable steps is to have a written harassment prevention policy. When a claim is brought, an employer must investigate the claim promptly and thoroughly. Why? Because there are cases that are pretty clear that says the lack of a vigorous investigation suggests that an employer has a disregard for the truth, and that is a terrible instruction to have read to a jury when an employer is charged with sexual harassment. And when it's necessary to enforce the claim or necessary to address the issue and resolve it, the employer needs to address that once they have an investigation that indicates that there are issues in which the employer needs to resolve an issue in the workplace. And they need to train supervisors. Why? Well, in California, it's mandatory that if you have 50 plus employees, they must undergo, the supervisors must undergo at least 2 hours of training every 2 years. And that's a requirement for 50 plus employers, but quite frankly, that should be a standard for almost all employers. There should be sufficient training of supervisory employees so that they understand their obligations and they know how to point out when there is an issue involving a potential harassment claim. And I was having a conversation with Abe here before we started. I would say that of the sexual, and I've received a lot of sexual harassment defense claims over the last year, year and a half. I would say that the vast majority of them, probably 60%, have involved a retaliation element to the claim, which is essentially an employee feeling that because they participated in making the claim or participated in the investigation, they were retaliated against by the employer. It is a separate and independent cause of action from the original harassment. It should never be tolerated. So a lot of these claims get addressed at the administrative level, either the Department of Fair Employment and Housing or the EEOC. So I've had conversations with the EEOC investigators who've come into a place of employment and have asked to interview the supervisory personnel. And what they typically do is go straight to the top. They want to know that there is buy-in at the top of an organization that would indicate that they believe that harassment prevention is a critical policy for their organization. So in one of my conversations with an investigator, he said, look, you know, there's this quote that I thoroughly believe in and that the EEOC believes in. And I heard it, and he says, what matters is not the example of your power, but the power of your example. And the whole idea is that so much of these problems deals with the shift in differential in power in the workplace. And I thought about that, and I've kind of used that for a number of years. And one of my employer clients came to me and said, hey, I like that quote. Where did you get it? Well, I don't know where it came from. So I went back and, went to the ultimate source of information, Google, and checked it out. Well, what I found out wasn't exactly heartening. The source, the person who originally is attributable to that quotation is none other than this gentleman, and he's probably not the poster child for sexual harassment prevention, but nonetheless, he said it, and it's a pretty good and pretty usable quote anyway. So that's all that I have. Abe, do you have anything else you wanna add in conclusion here?
No, I just think I think that you covered everything very well. And again, it goes to how the response occurs, and it goes to how well your system changes its lifestyle, because the pushing things aside that is what it has ended, in my opinion. It's creating a system to deal with these things effectively, efficiently, and getting harassers or this type of conduct to terminate and to end at the end of the day. I mean, that's the best prevention is not to have it happen in the first place. And the second best prevention is to have a policy that is open with the employees and the employer as well.
We're there. All right. Well, I really want to thank Dustin, Jane, Richard, Abe, and John. This has been a first in that I think we've put more subjects and had more excellent presentations than we've ever had in the past. And as is so unusual, we actually have time for some questions. So I really would put the floor open and encourage those of you who may have some questions on the presentation to do so now, if you can. Dustin, do you need to give them instructions on how to do that?
Sure. So if you'd like to ask a question to any of our presenters today, you use the questions panel in the GoToWebinar screen. And so while folks are doing that, I'll make one more reminder about our annual legislative day that's coming Monday, March 12th in Sacramento. If you'd like more information about that, you can go to our website, cmba.com, and register so for that. So we do have one question. I think this is directed at you, Rich. So the question is, are the RFIs an attempt to keep everyone busy until the CFPB runs out of money and the CFPB is forced to shut down because Congress will not appropriate funding for the CFPB?
I think they really are legitimate attempts to get response from the industry on the various functions of the Bureau. And the Bureau will not run out of money because they have $177 million for this quarter, and they actually don't get money from Congress. That's one of the interesting things. They get its money from the Fed, and based on the Fed budget for the fiscal year, it's somewhere around, they could get a total of $630 million. So they're not going to run out of money. They've got plenty. And I really do think it's really an effort to get input from the public, and particularly the industry that's been subject to a lot of the enforcement and CIDs on issues. And there are a lot of important points to make because a lot of the process was abused, where frankly smaller companies, they just had to settle because they were several $100,000 into an investigation, and they just threw in the towel. It just, you basically said, let's settle on something because I can't afford to go on, and that needs to stop.
Richard, may I ask a question? What would you say is the takeaway as the major difference in the strategy statement issued by Mulvaney as opposed to the strategy statement of the CFPB as it existed before?
I think the biggest is that the Bureau will enforce laws that Congress has enacted and not try to create new law, which is what the Bureau under Director Cordray was doing. And that if they find a practice they deem to be illegal, they're going to make it clear to the industry, and then only after it's clear to the industry and the industry's given time to react will they then enforce. So I think that's a big difference, that they're going to be more judicious and frankly more respectful in the use of their power.
So do you see this distinction between regulation by enforcement as opposed to as being distinct from what Ms. Mulvaney is now talking about?
Yeah, he wants to do regulation by rulemaking, and it's, while the former director and would actually say they very much disagreed with rulemaking by enforcement, we said, I just have to disagree with you because you don't like the only rules you wrote were the ones that Congress told you to write. When we ask for further guidance on the rules, you won't give it to us, but you will enforce. And so what we saw was former director who had been an attorney general liked using enforcement and did not like using rulemaking, since they are a regulator, we think they need to use rulemaking and then use enforcement where appropriate.
All right, so Rich, we've got another question for you here, and the question is, what has the latest feedback been in 2017 from small companies being audited by the, quote, new CFPB? Oh, I guess that's, what is the latest feedback from 2018 then from small companies being audited by the, quote, new CFPB?
We haven't heard yet whether there'll be any shift in the supervisory process, and the RFI on that we think may inform the Bureau. Even with Director Cordray, though, from what we understood, the Bureau wasn't sure yet at what point it was going to draw the line. The very small companies, and that's the question, what was very small, but we did get the understanding that probably they would stop at a certain level and leave the smaller companies to really be regulated by the states. Where we weren't sure is where was that? At what point was that line in terms of regular supervision? We have seen them get down to smaller companies, but I haven't seen yet them get to a company that I was surprised they got to. There were companies that were expecting them to get to because they operated in many states, and they had a big enough volume, I think, to attract attention after a while. But it took the Bureau about 6 years to get to them. So I think, though, once we see what the Bureau's response to the supervisory process, maybe we'll see a little more transparency in exactly who they will supervise and who they may really rely more on the states. That would be helpful, I think, because it's a big question mark for a lot of entities, and more guidance there, more transparency would be helpful.
All right, thanks, Rich. And we've got, looks like, just a couple more minutes. So if anyone has any last-minute questions, now's the time to put it up, or use the question module and enter your question. I will also point out that if you're a member of California MBA and would like to join the Legal Issues Committee, then one benefit that you can get out of that is we hold members-only calls in between our webinars here that you're on right now. And our next members-only call is going to be this coming April 4th at 1 p.m. Pacific. So if you're a member of California MBA and would like to join the committee, feel free to shoot me an email, dustin@cmba.com, and I'll get you signed up and get you information about that call coming up on April 4th. With that, David, I don't see any other questions, so I'll turn it over to you to close this out.
I had one quick question, then we'll close it out, which was really directed towards Abe and John. You made an interesting comment about being concerned about what the UPS delivery person does. Do you think someone who uses that service can be held liable for the actions by the UPS delivery or the FedEx delivery guy?
Well, the short answer is yes. The employer is obligated to create a harassment-free work environment. And so if the employer has any control over that, it is on notice. It's the employer's obligation to make sure that that behavior stops.
Thank you. Well, I wanted to thank everyone for attending. We had a very robust program today, and I hope you'll attend the April 4th meeting, because that's where we get the ideas for timely and complete subject matters that are of interest to all of us who are involved in the mortgage industry. And so to Richard, John, Abe, Jered, and Jane, and of course always to Dustin, thank you all very, very much for attending. And I think we just about completed the session. Thank you.